E Sabrina, por favor, fique à vontade, conduza os trabalhos. Estarei aqui para tentar ajudar da melhor maneira possível. Ok?
Obrigada, Ricardo. Lu,
Valeu.
você quer introduzir o professor?
Oi, perdão, Sabrina.
A Luísa vai fazer a introdução do professor
tá.
Ryan. Em seguida, você fala, Luca, tá bem? E no final as perguntas, acho que vai ficar bem organizado assim.
Hi everyone, I'm Luisa. I'd like to extend a warm welcome to our guest today, Ryan Abbott. Ryan, MD, JD, MTOM, and PhD is Professor of Law and Health Sciences at the University of Surrey School of Law, Adjunct Assistant Professor of Medicine at the David Geffen School of Medicine at UCLA, and a mediator and arbitrator with GEMS, Inc. He's the author of The Reasonable Robot, Artificial Intelligence and the Law, published in 2020 by Cambridge University Press. He has published widely on issues associated with life sciences and intellectual property in leading legal, medical, and scientific books and journals, and his research on it has been prominently featured in the media, including in the New York Times, Wall Street Journal, and Financial Times. Professor Abbott has worked as an expert for, among others, the United Kingdom Parliament, the European Commission, the World Health Organization, and the World Intellectual Property Organization. He's a licensed physician and a patent attorney in the United States, and a lawyer advocate in England and in Wales. Among all these things, a curious fact about Professor Ryan is that he was previously a prison doctor, which means he has firsthand experience when he writes on AI in medicine or in criminal law. He has 3 daughters and many professional experiences, and he's assuredly a very busy man. So we're most thankful for his presence here. Thank you, Professor Abbott. And here we have Professor Abbott, and as this video shows, he's Jarvis AI. We have 2 Professor Abbotts today. Thank you, Professor, for a kind gesture, and we're so glad we can learn from you today.
Oh, thank you. It is a real honor to be here, and I'm very excited to speak with everyone.
Thank you, Professor.
Professor, if you like to start, the words yours.
Oh, okay, great. Excellent. Didn't want to miss my cue, so there we have it. And can everyone see this all right?
Yeah.
Okay, I do apologize if my internet connection is not
And
that.
now we're gonna hear a little bit from Professor Luca.
Oh, sorry. All right. Still me, right? Sorry, I had a little bit of internet lag, but we're back, and it's okay because artificial intelligence is not yet running these things, or it would be a lot more seamless, although we wouldn't have been invited. You know, this is a exciting time for people who are interested in artificial intelligence and the law, in part because artificial intelligence is doing some really cool stuff these days. And not necessarily doing new stuff, but doing stuff that it used to do only a lot better. So for example, AI has been making music under circumstances in which you don't have a traditional author, at least from a copyright sense, for at least several decades. But historically, no one would really want to listen to that music except as a novelty. It was really, really bad. And now AI is getting to the point where it can pretty easily make mediocre music. If you go to the OpenAI jukebox, you can listen to music in the style of Katy Perry or Elvis Presley or Frank Sinatra, and it's not great, but it's not terrible either. And one of the interesting things about AI doing this is that once it is able to make mediocre music or even good music, it can make almost an unlimited amount of it at almost no additional cost. And for those of you for whom making music is not impressive enough, or writing short articles or books or making short videos, AI is doing some pretty interesting scientific stuff. Company owned by Google's parent Alphabet announced they had an algorithm that dramatically outperformed all the other teams in an annual competition of predicting protein folding. And that is a competition where a team is given a two-dimensional sequence of protein, and they have to predict what it will look like in 3 dimensions. And this is important because while AI has managed to outperform people at some interesting things like playing chess or playing Go, or maybe even in StarCraft, there's not a lot of practical value in being the world's best Go player. But there is practical value in predicting protein folding, because this is a core aspect of research fields like drug discovery. Predicting protein folding accuracy might be something that gives a company doing drug development a competitive advantage that serves as the foundation of a new invention. And so, at least in some contexts, AI seems to be outperforming people in scientific discovery. If November is too far away, this came out a couple of weeks ago in the journal Nature, and this was again a team from Google that found an AI that used deep reinforcement learning was able to design chip floor plans, which essentially does a design of a microchip, which affects its function. It takes multidisciplinary human teams months to do this, and it took less than 6 hours for the AI to make a chip. Not only was it much, much faster than the human teams, but it designed chips that substantially outperformed chips designed by the human teams. Designing chip plans, which has a special sort of intellectual property protection in the United States under a sui generis regime, is something that is traditionally eligible for intellectual property protection. And here we have an AI doing the same thing a team of humans would be doing, but better and faster. It's also interesting that, in my research, I have looked into some of the earlier instances in which people have claimed to have AI make patentable inventions. And the first case I could find from the 80s was at Stanford University, and involved a machine with an expert system generating a chip floor plan back in the 80s. So this is something AI has been doing for a long time, but is now doing it at a commercially viable scale, or close to a commercially viable scale. This is a case study that Siemens has been presenting. They announced it, as far as I'm aware, at the 2019 first conversation on AI and IP held by WIPO. And on the left, the green is a conventional car suspension, and on the right is a novel car suspension designed by an artificial intelligence. And Siemens wanted to file for a patent on this, but found they were unable to do so because all of the engineers involved in the project said that none of them were inventors, that they had an AI that was built to solve design problems. They simply gave it existing designs on car suspensions and told it what they were looking for. And the AI did the traditionally inventive part of this design process and came up with something new. And all of the engineers involved said the value of this component was obvious, and none of them thus did anything inventive. And that isn't entirely vanity on their part. In the United States, for example, it is a criminal offense to inappropriately list yourself as an inventor on a patent application. But the result of this was Siemens was unable to go out and file for a patent. These and other very interesting challenges raised by AI in the intellectual property space have not gone unnoticed by policymakers and intellectual property offices. At the end of 2019, the US Patent and Trademark Office announced 2 requests for comments. So these are seeking public comments on how AI will impact IP. One was on patent issues associated with AI, and one was with all other forms of intellectual property associated with AI. They had a report come out in 2020 that largely found that the status quo was acceptable. The United Kingdom Intellectual Property Office did something similar last year, and they came out with their report toward the beginning of the year. Their report, however, finding that there do seem to be some more significant deficiencies with the IP system, and that potentially some legislative change is needed. aside from patent offices looking at this sort of thing, there have been several high-profile expert reports or government agency reports in recent years on AI and IP and AI more generally. This report came out a few months ago from the National Security Commission on Artificial Intelligence. So this was a commission associated with the US government that was chaired by Eric Schmidt, who was previously the CEO of Google. And it is a wide-ranging report, 700 pages or so, that talks about essentially the US's industrial strategy around artificial intelligence. It concludes that the United States is simply not competitive with industrial strategy and AI, and it has a chapter devoted to AI and IP, arguing that AI and IP is not only a critical component of industrial strategy, but also a matter of national security. And these are some of the issues they raised in that, some of which are more traditional sorts of issues that AI tends to raise, like protection of data or protection of computer implemented inventions, which are like getting software patents. Much of this was also focused on China's role in the AI arms race, but some of it also on some of these unique issues like inventorship by AI, and more of those to come. The European Commission has very recently come out with a set of draft regulations on regulation of AI. These are not so much focused on AI and IP, but they are the first sort of comprehensive regulatory strategy for AI from a major jurisdiction. And this is somewhat like GDPR, but for AI in Europe. It is probably about 6 years away from being implemented, but it prohibits certain uses of AI, puts a lot of regulatory structure around some other uses of AI. And it is, again, kind of part of the bigger picture on what policymakers are thinking about with AI and regulation, for which IP is a component of this. Finally, in terms of who is discussing this, WIPO, the World Intellectual Property Organization, which is the UN agency that is most directly responsible for intellectual property strategy, has been having a series of conversations on AI and IP. They just announced their fourth one, which is going to be more on data. WIPO is not trying to find necessarily solutions to these problems, but to help identify issues and encourage member states and stakeholders to be in conversation. Indeed, the IP system is fairly well harmonized internationally, and with different jurisdictions coming to different conclusions on these, there is certainly a risk with some benefits and some costs to countries like Brazil and the US and India and South Africa, having different sorts of protection mechanisms for things associated with AI. There's a lot of interesting issues raised by AI and IP. Again, a lot of them aren't new issues, but they are issues that are taking on new importance. For example, protection of data is something that has been discussed a long time. The EU has a special sui generis database protection right that is largely kind of not thought that highly of, but protection of data takes on some new importance and characteristics under AI, because data can be used to train AI and make AI more efficient. Data can also be used by AI, and value generated from it in ways that you couldn't without AI. So for example, using AI to recognize patterns in very large data sets. AI also kind of brings new importance to computer implemented inventions, which is whether you can get patent protection for essentially software or uses of software, because now with AI, some of these technologies are more valuable and there is an increased interest in filing for them. It raises all sorts of interesting issues in copyright, where an AI may be functionally infringing someone else's copyright, whether that constitutes infringement, or whether there are exceptions for text and data mining, for example, of copywritten material. Even in things like trademarks, where a AI may be acting as an average consumer now, if you ask Siri to buy something for you, and now suddenly the use of trademarks has changed, and whether an AI could be infringing that sort of thing. So, the rise of AI has all of these interesting legal and intellectual property implications, and policymakers are actively now discussing what we should be doing about these. I want to focus on just a couple because they're near and dear to my heart, starting with this issue of an AI generating an invention without a traditional human inventor. And people have reported this has been happening for decades, but I am part of the team that has filed the first application explicitly arguing that this has occurred. This is our PCT application for it, and you can see in that blue box over to the top right, well, I'm pointing, but that doesn't make a lot of sense here, does it? That the applicant is Stephen Thaler, who is the owner of an AI called Dabus, which is the inventor. Dabus, the invention, was generated by an artificial intelligence. That is a long surname, but we wanted to get it all in there. And so people have claimed an AI can do this sort of thing in different ways, but just to give you some sense of how it is that a machine could invent something, this is a version of Dabus's predecessor from the 1990s. It is an artificial neural network where essentially you have a collection of artificial neurons that are connected to each other with varying connection weights. Those are illustrated by those lines above. When you show the first network information, say computer chip floor plans, it memorizes that data by altering the connection weights on the neurons. And if you show the first network that data again, it will tell you if it recognizes it as something it has seen before or not. Once that has been trained on that data, the first network can essentially automatically adjust its own connection weights. And this has the effect of corrupting the data it's been trained on. And this generates new computer floor plans that have never before been seen. If you train a second network to be a critic network, if you show it the data the first network learned on and have it see what's coming out of the first network, it will say, well, this is new, this is different than what the first network was trained on. And if you give it some performance criteria, like we're looking for a computer floor plan that uses less electricity, it can also identify when you have something that has value coming out of it. In modern versions of this, though, the machine now uses hundreds or thousands or more neural networks, each network encoding for a concept. So a concept could be verbal, it could be something like professor and synonyms for that, lecturer, teacher, educator, and so forth. Concepts are connected through mentorship to one another. So you get things like academics and boring, or money and goods, or heat in California. And in early iterations, mentors train basic concepts, and then in later iterations, the machine unsupervised combines basic concepts into complex ones and can identify when it thinks it has an idea of value. So in two instances, it generated what was otherwise a patentable invention, a beverage container based on fractal geometry, which is like a snail shell. So this could help with transportation and storage and grip of beverage containers. And the other one is a flashing light that could attract human or AI attention in an emergency situation. But in our case, the person who developed this machine didn't tell the machine to solve either of those problems. He didn't train the machine to solve either of those problems. And the output wasn't an area that he had expertise in, and the output was obviously valuable. So we argue that he did not meet inventorship criteria himself on any traditional means, and that the AI was functionally the inventor. That is why we named it as the inventor on these applications, because it functionally invented to prevent someone from taking credit for work they didn't do. Indeed, if he sold that machine to me, it would really change the meaning of being a human inventor if I could list myself for 1,000 inventions made by this machine, and to inform the public this was an AI-generated invention. Of course, no one has really claimed, we've certainly never claimed, that the AI would own the patent, but it is most commonly the case that inventors do not own their own patents. Their companies and employers own their patents. And so in this case, we argue that the owner of the AI would own its patents under common law doctrines of accession or first possession. Before us filing this case, there wasn't a lot of law in the area, but there was law on the related subject of computer-generated works. The United Kingdom in 1988 was the first, was not appreciating that computer comment. The United Kingdom was the first country in 1988 to statutorily protect computer-generated works. This is a work otherwise eligible for copyright protection for which there is not a traditional author. And when that happens, the producer of the work, like a film producer, is legally deemed the author, fictionalized to be the author, and the work receives a shortened period of protection, 50 years rather than 70 years plus life. Of course, 70 years plus life wouldn't work with the machine because the machine never dies, and also it's never alive. And who needs 70 years plus life anyway if you're not Disney? But there you have it. The US, on the other hand, since at least 1973, has gone in the opposite direction, and they have a human authorship requirement. So if an AI makes a very valuable song that becomes a best-selling hit, no one can own that. It's in the public domain once it's released. That makes it awfully tempting to take credit for work that an AI has done, and the AI is unlikely to complain. This is not a statute. This is an administrative agency policy that has never been challenged in court. And it is based now on the 1880-something case of Burrow-Giles v. Cerrone. That case involved this famous picture of Oscar Wilde. And it was a case before the Supreme Court where the Supreme Court was answering whether a photograph could have copyright protection. And the Supreme Court held that any tangible expression by which an idea in the mind of an author is given tangible expression is eligible for copyright protection. And the Copyright Office has held that to mean that because machines lack minds, you cannot get protection for anything that comes out of them. Also, monkeys. This case was almost, this policy was almost litigated a few years ago as a result of the monkey selfies. This involves a series of pictures taken by a black-crested macaque named Naruto, pictured here, of himself in 2011, using cameras belonging to the nature photographer David Slater. That is not a happy macaque. Macaques smile as a display of aggression, so it is looking at a macaque in the camera lens and not liking what it sees. But in any case, Mr. Slater tried to sell these photographs, arguing he owned the copyright in them. Other people used them without his permission. And the Copyright Office eventually announced that photographs taken by monkeys don't receive copyright protection. That seemed to be the end of the case until 2014, when PETA, People for the Ethical Treatment of Animals, sued Mr. Slater in district court in California, arguing that the monkey owned the copyright and they were going to bring the lawsuit on the monkey's behalf. That case was dismissed at the Court of Appeals in the Ninth Circuit, but not on the basis of the copyright policy, the human authorship requirement. It was on the basis of standing. So the court said, unless Congress very plainly states that monkeys are allowed to sue, monkeys are not allowed to sue, and therefore we are getting rid of this lawsuit. So that policy has never been litigated. And as far as we are aware, this is the first case, our case, of whether a invention made by an artificial intelligence without a traditional human inventor can receive copyright patent protection. So far, the patent has been rejected in the US, the UK, Europe, Germany, and Australia. But all of these rejections are under appeal in the court system. At the end of next month, we have a hearing in the Court of Appeal in the UK. We last month or a month before that had a hearing at district court in the US. And in December, we are having a Board of Appeal hearing at the European Patent Office. It's pending in about a dozen other countries, including in Brazil. And yeah, in the European Patent Office, the European president has recently asked to intervene in the case, and the board has directed him to answer two questions: whether having a human inventor is a core component of having an invention, or whether it's just there to acknowledge moral rights of inventors, and whether the European Patent Office should be addressing this issue at all in light of the fact that the European Patent Convention leaves inventorship issues to member states. But in the other jurisdictions, in the UK and in the US, it has come down to really very narrow questions of statutory interpretation, whether or not patents acts in those countries use language that refers to inventors as natural persons, or if that language is more flexible. But it is our position that these inventions are no less worthy of protection, because even though an AI doesn't care about getting patents, the people who invest in building and developing these very sophisticated AIs do care about patents. And if an AI is able to generate socially beneficial invention as well as a person, there's no reason to discourage that sort of innovation. So that's a little bit on our are AI-generated invention cases. And just to give another snapshot of one of the other interesting areas impacted by AI is the standard of non-obviousness in granting patents, or a person having ordinary skill in the art. Right now, to determine whether or not an invention is entitled to a patent, we ask whether essentially an average researcher in a field would find an invention non-obvious. And that standard essentially, again, represents an average researcher, but average researchers are often using AI these days and using it in ways that make them more sophisticated, because they can do new sorts of problem-solving tasks like pattern recognition and big data sets, and because it makes them more knowledgeable because they have access to more prior art. So AI may already be expanding the concept of a skilled person. And at some point right now, inventive AI is just a very small part of the research and development ecosphere. But at some point in the future, when it becomes standard for people to use inventive AI to solve problems in certain fields, for example, to develop a new drug to a new pathogen like COVID, Pfizer and GSK and Moderna may just go to their AI and say, here's the new pathogen, what will treat it best? When an AI becomes, for all intents and purposes, the skilled person or the average researcher, that is really going to change the standard for getting a patent, because there will be a lot less that is non-obvious. Just to give some sense of what that might look like, this is a picture of an antibody, and all of the best-selling biological drugs are monoclonal antibodies. These are drugs like Humira. They are essentially modeled after antibodies that your body makes, although they're generally made, anyway, a little complicated, monoclonal antibodies versus non-monoclonal antibodies. But the purpose is your body can make a whole lot of antibodies. We don't know exactly how much, maybe trillions or more, enough antibodies that human researchers could be looking at these things forever. But it's not too hard to imagine a machine makes a quintillion antibodies really very quickly. And by publishing those sequences online, you couldn't get patents for them, but it might prevent other people from getting patents on them. And AI in drug discovery is now doing things like predicting how antibodies will target antigens, predicting how they will interact with other drugs or other targets, predicting how to formulate them, designing clinical trials, or at least first passes of this. It's not too hard to imagine in 10 or 20 years, an AI could sequence every possible antibody and tell you what each of those antibodies could be used for. And that could either get one company all the patents in the world they want on antibodies, or if published, just prevent anyone else from getting antibodies at all. As computers increasingly get sophisticated with no obvious upper bound to how inventive a machine might come to be, it may be that someday everything is obvious to commonly used artificial intelligence, in which case you wouldn't really have any more patents because everything would be obvious. That wouldn't be so bad though, because the cost of innovation would be trivial, and AI could make a new invention with as much effort as it is now to make a song that sounds like Katy Perry did. And just to kind of end on this note, this is one area, intellectual property law, where AI is going to have this sort of impact, but really it is going to have this impact on many other areas of the law. This is the subject of my new-ish book, which is getting translated to Portuguese now. So that's exciting news. We've even got the translator with us today. In torts, with self-driving cars replacing taxi drivers, doctors, and lawyers, there's going to be competition there for being a reasonable person or causing accidents. In tax policy, AI replacing someone at a McDonald's teller is subject to a very different tax regime than a person. And this encourages businesses in different sorts of ways to automate or not. There are really a lot of ways in which AI is going to impact these standards. And, now is a good time for us to be talking about them. So that brings me to the end of my 30 minutes or so, and we'll look forward to speaking with you all after Luca's talk.
Thank you so much, Professor. God, so many questions already in my head. And we're so glad to know that the book is going to be translated to Portuguese, so we all can have more access to it. That's such a nice news. Thank you. I'll now introduce you, Professor Luca, and I'll do it in Portuguese, all right? Bom, gente, agora quem vai falar conosco é o professor Lucas Chihu. Chihu, né, professor? Não estou pronunciando errado.
Isso aí, certíssimo.
O professor Lucas Chihu é advogado especializado em Direito e Propriedade Intelectual pela PUC-Rio. Ele é sócio do escritório Baril Advogados, doutor e mestre em políticas públicas, estratégias de desenvolvimento pela UFRJ, pesquisador do Núcleo de Pesquisa em Direitos Fundamentais, Relações Privadas e Políticas Públicas, o NUREP, e do INCT Proprietas.
Proprietas.
Ah, tá. É diretor executivo do Instituto Brasileiro de Direitos Autorais, professor assistente na Universidade Positivo, professor convidado do curso de pós-graduação em Direito de Propriedade Intelectual da PUC-Rio e do curso de pós-graduação em Stricto Sensu em Políticas Públicas, Estratégias de Desenvolvimento da UFRJ. Esse é o mini currículo do professor Luca e a gente está muito feliz de tê-lo aqui. Professora, a palavra é sua.
Puxa, obrigado, Sabrina. Obrigado, Sabrina. Obrigado, Ricardo. Obrigado, Luísa, Arumi, todo mundo da ANAD também. É uma grande honra, uma grande felicidade estar aqui com vocês. Se vocês me permitirem, eu até tinha conversado com a Sabrina de fazer a fala em inglês e com algumas intervenções em português, para quem preferiu o português também, que a gente faz o debate, também envolve o professor Ryan também nesse debate do que a gente vai levantar aqui e faz aquele grande debate no final com todo mundo participando. Pode ser, Sabrina? Vocês...
Com
Pode
certeza.
Ser? Então,
Professor, he's going to speak a little bit in Portuguese and a little bit in English, so we can discuss as well if that's okay.
Então, só vou compartilhar aqui a tela dos slides e aparece para vocês os slides?
Aparece.
Maravilha. Só um minutinho. Bom, então tá bom. Então, vou começar em inglês e eventualmente faço algumas intervenções em português para resumir uma coisinha ou outra, tá? Good evening. First of all, I would like to congratulate the organizing committee, and Ricardo, Sabrina, Luísa, Arumi, and all my friends from ANAD for moderating and organizing this event, and also thank Professor Abbott, whose studies contributed a lot to my doctoral research. Speaking of which, during my doctoral research supervised by Professor Alan Rocha, I dealt with the appropriation regimes regarding AI products, especially those that, if created by human beings, would be protected under copyright. And that is what I would to talk with you today. Let's start with some background information. In 1950, Alan Turing questioned, can machines think? The questioning, as seen, is not current, and as tempting as may be, we will not delve into this issue here. Whether they can think or not, for now, let's work with another proposition. Can machines create? For this moment, let me propose a step back and a neutral look for the verb create as something stripped of any subjective aspect capable of restricting such action only to the human being. In that scenario, can the AI system create something that is distinct from what already exists and has characteristics of a product that, if it was created by a human being, would be protected by copyrights? Então, basicamente, aqui a gente pular a questão, que é uma discussão extremamente atraente, extremamente apaixonante, se realmente as máquinas um dia podem pensar, vão pensar, isso a gente ficaria horas aqui também conversando, falando sobre transhumanismo, pós-humanismo, então essa a gente conversa outro dia, se Deus quiser, mas para esse momento a gente realmente se perguntar, se a gente parar para olhar de maneira bem objetiva, né? Então, afastando momentaneamente aquele critério da originalidade subjetiva, daquele autor que está expressando a sua personalidade ali, será que efetivamente as máquinas já são capazes de criar algo que, se fôssemos nós criando, se fôssemos nós ali, como o professor Denis dizia, os originadores, será que teria proteção se a fonte não fosse um humano, mas a fonte fosse uma máquina? Então, alguns exemplos mostram que sim. Aqui a gente tem o Next Rembrandt, tem o filme também do Sam Spring, o roteiro, né? A gente tem esse recente aplicativo Voilá, a gente tem estudos também que a inteligência artificial ela contribui bastante no desenvolvimento, por exemplo, de medicamentos. So, several examples show that it does. Projects that seek to create a new Rembrandt, film scripts developed and recorded in 48 hours, systems that help develop drugs against COVID-19, and even tools capable of making our version in 3D or cartoon are just a few examples. Therefore, today, and disregarding the subjective aspect of the creation, machines can generate outputs endowed with significant originality. If expressed by a human being, such outputs will be certainly in the scope of protection of copyrights. So, where do we stand regarding these output-aid systems? Producing results comparable to those that a human being will be capable of. It's enough to claim they deserve the same legal treatment. Então, o mero fato deles produzirem algo equiparável a algo que seria facilmente atribuído a um ser humano ali, dado a complexidade estética, dado ali o caráter, a expressão ali artística, será que esse mero fato faz com que a gente possa aplicar o mesmo tratamento legal? Faz com que a gente possa simplesmente transplantar o que a gente tem em termos de direito autoral, em termos de propriedade intelectual para esses casos? Então, a minha opinião pessoal aqui, e não existe absolutamente mais apaixonante dessa discussão que não existe absolutamente uma resposta certa. Então, essa que é a maravilha, e por isso que eu também não vou me alongar para a gente ter o debate, porque aqui toda e qualquer ideia, não existe ficção científica mais. Então, já estou ansioso para saber o que vocês acham. Só que a questão não é tão simples, né? However, the issue is not so simple. It has been mobilizing researchers worldwide to structure solutions to balance the different interests involved, resulting in a series of models to accommodate this scenario to the existing copyright and related rights system. Before dealing with such models, however, it is important to comment on some of the aspects that support our position against the indiscriminate and the full application of the rules of the current system to AI products whose original content was mainly due to the processing of data from an AI system, not from human interference. The first one is that copyright was designed for humans, especially in systems based on droit d'auteur or author rights, o nosso direito autoral brasileiro. The expression of a particular author personality is protected. The protection is based on his intellectual efforts. It protects the author while recognizing the protection of his original work. Thus, regardless of the real intentions behind the legal test, it is clear that a system that, as in the case of Brazil, guarantees comprehensive protection for an entire life plus 70 years from the death of its author, and that does not require any formality, any register, any taxes, any fees, cannot be extended to other products without further consideration. Então, a gente tem um sistema tão amplo, né, de direitos autorais, a gente não tem a necessidade de registro, como tem de marcas, de investimentos, como tem de patentes ali, investimentos altos, né? Claro que tem investimento intelectual, mas é um sistema extremamente compreensivo, um sistema que muita gente até brinca que não é nem o direito do autor, é mais o direito do herdeiro, que vai ter 70 anos. Então, o autor velhinho, ele vai ter menos tempo do que os herdeiros, e é um sistema que é gratuito, é extremamente compreensivo quando a gente vê o artigo 29, né, quais são os usos que ele compreende. Então, será que a gente pode simplesmente transplantar, aplicar exatamente o que a gente aplica para essas obras? Ainda mais sabendo que, ainda que não fosse exatamente pensado ali só no autor, naquela coisa bonita da criação, mas ele foi pensado, sim, no esforço humano, ele foi pensado, sim, na figura do autor. Tá? Although it has already been argued that copyright was structured around the human author, the absolute anthropocentrism and the figure of the romantic author are just a moment, are just an episode in the history of copyright. Related rights, the protection of technical and functional products, and the investment-oriented protection grow under the discourse of the protection to the originality of the protection to the author. And as Ascensão said, we are not here arguing against investment protection, but questioning whether such protection must be sheltered in the copyright system. Então, o que a gente diz é exatamente, se a gente teve lá no cerne, lá na origem do direito autoral, aquela preocupação, né, lá no 1700, no Estatuto da Rainha Ana de 1710, um ato de encorajamento ao aprendizado e à leitura, a proteção do autor ali, teoricamente, como um discurso para a gente criar essas normas, né? Então, isso se teve lá no início, na Gênese, mas já agora a gente vê no Brasil, por exemplo, já a partir da década de 70, o que era aquele núcleo, o que era aquele objeto da proteção, que era o autor, que era a obra original, começa a se expandir. a gente começa a proteger elementos que não são obras, por exemplo. Então, fonogramas em si não são criações intelectuais como as obras protegidas lá do artigo 7º, né? A gente tem também os programas de computador, que são amplamente criticados, por exemplo, o professor José Ascensão, por serem protegidos pelo mesmo instituto do que a gente tem uma obra de arte, o que a gente tem uma ilustração, um quadro, uma pintura, uma música, porque ele tem um aspecto bastante funcional, bastante técnico. Então, a gente já ampliou esse escopo, né? Agora cabe com uma nova camada, a camada em que essa origem, esse desenvolvimento já não sai mais diretamente do humano, mas sim sai da máquina. Qual vai ser a nossa opção? Continuar dentro desse sistema, e como o professor Alain sempre comenta nas aulas dele, né, fazer mais um puxadinho na nossa lei, ou a gente vai, inclusive, ultrapassar ali essa camada, a gente vai ultrapassar o próprio sistema de direitos autorais e conexos, né? So, today, the new layer brought by the AI outputs, the technocentrism in which computer systems assume a leading role and challenge the creator role previously enjoyed by human beings, imposes new challenges on how we treat such products within copyright and related rights system. So, it will be treated inside the system or outside the system. To help us on this matter, it is worth commenting on one last point about the structural foundations of our system, the incentive. Here, there is no incentive to the actual offer, or as Anne-Marie Briere puts, the author in fact. If there is any, the incentive is for the investors behind the projects, for the developer, or for some other human figure, which could also be considered carefully. Otherwise, it will pose threats to the necessary and often overlooked balance between the public and the private interest behind the IP rights. Perhaps a way to eliminate the discussion regarding the treatment of AI outputs by copyright would be to continue to assign copyrights to the human author when the systems are used as a mere tools. Low system autonomy and significant and creative contribution by the human being would allow for the maintenance of the current system. On the other hand, if the system performance was decisive for the original content, it would be in the public contribuição ali que determinou o conteúdo artístico, se a expressão artística, entre aspas, estiver sendo ditada pelo processamento do sistema, não tiver tido uma contribuição criativa do ser humano, a gente teria o domínio público como resultado disso, porque não existe obra sem autor humano dentro da nossa legislação. Agora, o que é essa área cinzenta que a gente tem, né? O problema é que, como tudo no direito, nada é tão fácil assim, é sempre um enorme depende. E esse depende aqui é gigantesco também, porque, infelizmente, a vida não pode ser reduzida quando a gente trata desse problema a essa equação. Porque, no caso que a gente fala dos extremos, esse desenho aqui do quadrinho do lado direito é absolutamente ilustrativo, porque os extremos eles são minúsculos e a área cinzenta é enorme. Tá? The problem here is the 50 shades of gray, and maybe 50 is not enough. The gray area is huge. There are countless combinations between system autonomy and human interference to the point that predictability is not easy to measure. Starting with the autonomy of the system. I see that it could be twofold. The intrinsic autonomy related to the operation of the system itself, and which comprises the degree of technical opacity related to that system or technology, how much it is possible for a human being to interfere, and how it should interfere. The how here is very important. If it is essential to understand whether a given contribution is creative or not, therefore it is vital to understand the role of the human in the different AI systems. For example, In a neural work system working under supervised learning, the role of the human exceeds the development of the system and demands greater interference in the selection, organization, and labeling of the training database. In expert systems, we would have, in most cases, two specialists, one from the area of expertise, for example, a physician like Professor Ryan Abbott, and the system expert who will have to translate the medical rules into the expert system. In genetic algorithms, we have an important interference for the human being as defining the fitness of the model and so on. These are only 3 types of the system, which represent only a part of the universe of available technologies. It is possible to observe the dimension of the problem, which is not mitigated by the analysis of the next item, the extrinsic autonomy. In other words, how much a human being interferes by his own decision. And such interference can be individual, multiple, creative, and non-creative, and commonly the outputs being discussed here are the results of work of a team composed of several specialists in information technology, arts, mathematics, among others. Então, basicamente, quais são as preocupações, algumas das preocupações relacionadas àquela área cinzenta enorme, né? A primeira delas é quanto à tecnologia. A gente falar um produto criado por inteligência artificial é muito complicado porque isso a gente está simplificando demais. Às vezes, no mesmo projeto, são usadas diversas tecnologias de inteligência artificial. Cada modelo, cada tecnologia de inteligência artificial pode demandar uma ação humana diferente, pode ter, inclusive, um nível de opacidade técnica, no sentido de o quanto eu consigo controlar e entender tudo que está acontecendo naquele processamento, diferente. Então, não é o humano que necessariamente vai determinar tudo. Ele pode determinar, sim, qual é o grau de controle que ele pode ter, que ele quer interferir, que ele quer contribuir, mas existem aspectos intrínsecos às próprias tecnologias. Além disso, esses projetos, às vezes a gente, por exemplo, ficar numa eterna busca por quem é o autor, para esses projetos pode ser complicado, porque a gente pode ter diversas pessoas contribuindo de maneira criativa. Aquele cara que seleciona a base de dados, ele pode eventualmente ter uma proteção, que a base de dados é protegida pelo direito autoral quando ela constitui uma criação intelectual pela sua seleção, organização, disposição. O desenvolvedor também é protegido pelo direito autoral quando ele desenvolve um software. A questão é, será que eu vou poder proteger o desenvolvedor pelas criações que o software dele deu resultado? Será que isso também não começa a afetar um pouco o equilíbrio do direito de propriedade intelectual? Porque não foi ele necessariamente que originou aquele produto lá no final. Claro que ele ajudou bastante, mas, enfim, é uma discussão bastante complicada para ver se não teria uma super premiação, por assim dizer, né? E agora, já caminhando aqui para o final, perdão, só abrir o chat aqui, eu acho que apareceu para todo mundo. Só um minutinho. Pronto. Então, o que a gente teria aqui no Brasil, né? Quando a gente fala, como a gente comentou naquele quadrinho anterior, seria o domínio público para essas situações que mais preocupam, né? Situações que quem define, de certa forma, quem que determina, de certa forma, o conteúdo artístico daquele resultado é um sistema de inteligência artificial. Quando a gente não consegue relacionar uma escolha criativa humana àquele determinado resultado com tanta clareza. E o professor Ryan Abbott trouxe vários exemplos aqui, exemplos em que diferentes contribuições, diferentes graus ali de interferência levaram a diferentes resultados, inclusive muitos, como ele falou do caso da invenção, que sequer sabia qual seria o problema que viria a ser solucionado. Então, é bem complicado a gente aplicar o que a gente tem hoje a isso, né? Então, a gente teria esse tipo de produto em domínio público quando a gente fala de obra intelectual. Tá? A gente tem na nossa legislação aqui algumas hipóteses, sim, que já podem resolver parte do problema, mas é só uma parte do problema. Tá? Então, continuando aqui, e aí já partindo agora para o mapeamento de alguns dos modelos que têm aparecido para buscar lidar com essa situação, né? Como a gente vai apropriar esses produtos, vou comentar um pouco deles aqui agora. So, as the copyright system in Brazil is structured today, and with some few exceptions, AI products generated without relevant human interference and endowed with great unpredictability would be necessarily in public domain. Although it's indisputable that the option for the public domain will be advantageous for several reasons, including the enrichment of the collection available for access, transformation, and other forms of use, certain practical factors and possible political and institutional maneuvers to maintain the interests of the rights holders can completely void the purpose. Concerning to the later factors, an alternative will be the promotion of a system that would already consider the interests of potential rights holders, which will be the final part of my presentation. In this figure, and in addition to the public domain, which represents the status quo in Brazil for most of the AI products, appropriation models are analyzed considering the original attribution of rights and the three main recipients, namely the creator, the owner, like an investor, employer, contractor, coordinator, organizer, and the AI system itself. It must be highlighted that we identified proposals towards a sui generis system under which AI outputs appropriation will be regulated through industrial property law, competition law, trade secrets law, and we will not delve in these models right now. Categorized as anthropocentric models, we have those in which the original attribution of rights is directed to the creator's person, to the author's person. For example, the category of models that promote protection similarly to the one verified in the computer-generated work system in the British legislation. Regarding the owner-centered models, although it could be directed to natural persons, these must be not confused with anthropocentric ones, since the attribution of rights is directed to the owners, to the rights holder, not to the authors. For example, investors, contractors, employers. The works made for hire doctrine will be an example. Each on its own way, the models presented so far will still be included within the extended anthropocentric paradigm. On the other hand, proposals regarding a rupture with such a paradigm are not rare. Technocentric models propose to concentrate the ownership of rights or to extend the attribution of authorship to an AI system. Under these models, we discuss situations in which authorship or ownership of an AI output would be attributed to another kind of personality, another kind of legal personality to be created. Both possibilities presuppose the challenge of attributing legal personality to AI systems and represents a significant rupture not only with the anthropocentric paradigm present in the copyright, but in the very conception of humanity and our legal systems. Então, aqui, vendo diversos modelos, inclusive a partir do artigo também do professor que está aqui presente, foi possível identificar alguns modelos, alguns grupos de modelos, né? Modelos que sempre buscam atribuir a um ser humano, aquele ser humano que teoricamente tenha dado origem àquele produto, a autoria. E aí a gente pode pensar, por exemplo, realmente no que a gente tem na legislação de 88 do Reino Unido. A gente pode pensar, existem estudos que propõem que seja dada a autoria ou os direitos sobre um produto da IA para o cara que selecionou a base de dados, porque aquele cara pode ter determinado conteúdo. A base de dados, ela realmente é bastante importante. Muitas vezes, ela é fundamental para treinar um sistema e para que a gente tenha um determinado resultado. Então, se o sistema, como é o caso do Sunspring, ele é alimentado com 300 roteiros de filme de ficção científica, e você espera que ele vá processar toda aquela informação e te gerar um resultado, provavelmente tu não vai saber exatamente o que vai acontecer no filme, qual é a complexidade psicológica dos personagens, como é que vão ser os diálogos, mas tu vai desconfiar que a temática vai ser de ficção científica. Então, a escolha da base de dados, muitas vezes, ela vai ajudar na definição, mas não com certeza, mas não sei se seria preciso a gente afirmar que esse cara deveria ser também o dono de tudo que é produzido a partir daquele treinamento. O outro modelo, que seria um modelo centrado no titular, ele está muito ligado ao que a gente tem hoje nos direitos conexos. Então, a gente fala, por exemplo, de um sistema que seria parecido com o que a gente tem de obras coletivas. Aquele responsável por organizar o projeto, organizar a equipe que trabalhou naquele determinado sistema, naquele determinado produto, ele poderia ser o titular dos direitos sobre o que é produzido dentro daquele projeto, né? A gente tem também lá nos Estados Unidos a doutrina do Works Made for Hire. A gente não tem mais aqui as obras sob encomenda, perdão, na nossa lei de direitos autorais, mas lá eles têm algo parecido que muitos autores, seja com poucas alterações ou do jeito que ele já existe, buscam aplicar para resolver esses problemas, tá? E os modelos tecnocêntricos, que são propostas que buscam atribuir, como o professor apresentou, né, ao sistema de inteligência artificial a condição de autor, de inventor ou de titular. Então, o que eu proponho aqui é que nenhum desses modelos sendo visto de maneira individual, né, nenhum deles sozinho seria capaz de solucionar a questão de uma maneira satisfatória. E, inclusive, já adianto também que o que eu propus ali na tese, o que eu vou apresentar aqui para vocês para a gente discutir, para a gente debater, também não é adequado. Se a gente for para pensar, todos eles têm brecha, esse também tem brecha. A ideia é que a gente consiga, de certa forma, extrair de cada modelo o que faz mais sentido com a realidade dessas produções. Então, a realidade não existe quem incentivar em termos de um autor de fato. Então, não há que se falar em incentivo, tem que falar em incentivo para quem investe. Incentivo ali para quem realmente está investindo dinheiro naquele projeto. Então, beleza. Então, eu vou pegar um pouquinho do fundamento lá dos direitos conexos, pega um pouquinho aqui do modelo azul. Por isso que ele está todo colorido. Ah, mas o que ele gera são produtos que têm ali uma complexidade estética, que ele tem uma expressão artística, sem entrar aqui na discussão do que é arte ou não, que não tenho nem formação para isso, mas no sentido de que aquilo gera algo que a nossa legislação considera como algo artístico. Então, pega um pouquinho do roxo e pega um pouquinho do amarelo, perdão, do laranja, porque, ainda que não seja um sujeito de direito, o sistema de área é central nisso tudo. Ele é o objeto, ele é aquele sistema que está por detrás também ali da produção do objeto. Tá? Então, de certa forma, o roxo e o azul eles não rompem com o paradigma antropocêntrico, falando de uma maneira mais ampla, né? E os tecnocêntricos, aí sim, aí eles dão um passo à frente, rompem de vez com qualquer paradigma antropocêntrico que a gente possa ter. Não que eles vão se excluir, mas sim pode ser aberto ali um novo caminho que pode ser explorado por outros modelos, eventualmente um modelo zoocêntrico direcionado para os animais, mas isso foi uma provocação do orientador e eu deixo também, eventualmente, para ele trazer aqui para o debate para a gente. Tá? Então, vou voltar ali só para finalizar. Vou voltar aqui só para finalizar, então, essa parte dos tecnocêntricos e a gente partir para a conversa, que é o que há de melhor. So, notwithstanding the proximity of its fundamental elements to the models mentioned above, they are not to be confused. I'm sorry, I just skipped a very important part. That is the presentation of the meta-apropriation models. I'm sorry, let me rewind a little. None of the appropriation models analyzed could individually and satisfactorily deal with the complexity inherent to the appropriation of AI outputs. That said, and considering the current stage of development of these technologies and the current copyright law, we understand that the best way to deal with the AI outputs is through the adoption of a hybrid regime, which we call the meta-appropriation system. Its theoretical foundation is very much alike that one related to the owner-centered models, especially related rights, since it focuses on the investment in its organization and the technical features employed. With anthropocentric models, it shares similarities with copyrighted works and their artistic expression. Finally, with the technocentric models, they share the fact that, although they do not treat AI systems as subjects of law, they are recognized as central to the development of an AI product that, in turn, represents the good to be protected. Notwithstanding the proximity of its fundamental elements to the models mentioned above, they are not to be confused. In this proposal, the AI system will not be considered as an author, and the AI outputs could not be regarded as a protected and copyrighted work as such. However, such factors do not rule out the possibility of recognizing that AI outputs and their regulation, which could be integrated into the copyright and related rights system. They are products endowed with originality, equivalent to artistic expressions, whose development requires investments and activities of both creative and technical nature, all elements already present in the current system. Ideally, the regulation would consist in a model within the copyright and related rights system, which could even make use of rules and definitions that already exist in our copyright law, the software law, international treaties, and other regulations of the subject matter to enable, as far as possible, the harmonization with the structure on the existing system. Other structural elements that can be considered are the following. First, only economic, property, patrimonial rights would be granted. No moral rights related because we don't have an author. In fact, we don't have a real author. We must work with a shorter term of protection, one that is adequate to the reality of this market. We don't need a lifetime of protection and 70 years after the death of the author. Just like Professor Ryan said, it doesn't. The AI system is not born and don't even die, never. It is recommended that such model addresses the ownership of property rights over the AI products in different situations, mostly considering the collective character of such projects. Also, it is crucial that any special legislation on property rights address the limitations to these exclusive rights. In this case, it can be done through reference to existing limitations, development of new ones, and the necessary amendment of our current copyright law, especially in Brazil, to comprehend a text and data mining limitation. Então, aqui, basicamente, seria realmente a gente começar a discutir o que teria, se a gente fosse falar em um direito sui generis, também é uma proposta de alguns autores aqui no Brasil e lá fora, pensar no modo de apropriação, no regime de apropriação sui generis, quais seriam ali os seus contornos, né? A gente aqui está falando da casca, mas para depois a gente conseguir aprofundar, entender como ele se encaixaria. E a gente já tem um modelo sui generis do direito autoral, que é a lei de software. Ela fala sobre um direito autoral, mas que não se encaixa bem ali na LDA, então foi preciso uma regulação específica, uma regulação sui generis. Isso seria algo parecido nessa dinâmica. Além disso, seria algo que poderia estar dentro do grande sistema de direitos autorais, mas, ao mesmo tempo, ele demandaria alterações em outras leis. Porque aqui a gente está falando sempre dos produtos, a gente está falando sempre do resultado, dos produtos criados por IA. Mas para eu gerar um produto desse, para eu gerar uma música, para eu gerar uma ilustração, eu preciso treinar um sistema. E como é que eu treino um sistema que vai me gerar imagens? Muitas vezes eu preciso treinar com imagens. Então, será que esse processamento, será que essa mineração de dados que aí falando dados lato sensu, né? Dados, imagens, textos, isso a gente não tem uma limitação na nossa lei de direito autoral que dá a tranquilidade necessária para que um empresário, para que um pesquisador faça isso. Lá na União Europeia a gente já tem, nos Estados Unidos com modelo de limitações ele já tem, no Japão já tem também, Singapura se caminha para isso, mas a gente ainda não tem. Então, além de se pensar nisso, a gente está pensando super otimista aqui no final. Mas, teoricamente, o meio do caminho hoje não é seguro aqui no Brasil. Isso pode não só prejudicar a gente internamente, mas pensando de lá para cá. Será que as empresas vão querer fazer investimento, trazer negócios em um país em que elas têm receio de fazer processamento, fazer mineração de dados? Então, a proposta seria que não só sejam pensadas limitações para esse próprio direito, né, para esse próprio regime de apropriação, mas também que a gente reveja todo o nosso sistema para ver o que a gente precisa fazer para acomodar essas novas tecnologias. So, the proposal of some guidelines on the structural elements for a meta-apropriation system represents just a small part of a vast discussion that has already been conducted worldwide and does not intend to fully satisfy the complex scenario involving the development of products through the use of AI systems. A lot of work remains to be done, and there is still a lot to learn, especially with regard to understanding the technical aspects of the system. For these reasons, I will end here and eagerly await for the debate with Professor Ryan Abbott, Sabrina, Ricardo, and all the colleagues here that are here present. Well, that's all I have to say. Thank you all for listening. E é isso, pessoal. Obrigado. Estou super ansioso para a gente conversar, para a gente trocar uma ideia. Isso daqui sendo realmente sem qualquer pretensão de alguma resposta, mas sim um compartilhamento de inquietações que me fizeram perder todos os cabelos ao longo dos anos para que a gente possa debater esse assunto tão gostoso juntos. Tá bom? Obrigado de novo, pessoal. Fiquei super feliz pela oportunidade.
professor, somos nós que agradecemos, que exposição incrível, e realmente parece ter muito mais pergunta do que resposta, né, até o momento. Nós temos duas perguntas aqui dos membros. We have two questions from our members. E depois nós temos a nossa garota das perguntas, que é a Arumi. Esse é o campo de estudo dela, propriedade intelectual. I have our girl from the questions here. It's Arumi Miyasato. Her field of studies is international. Oh my God, sorry. It's artificial intelligence and please help me. Property. Intellectual property. I'm sorry, it's a tongue twister. So we're gonna start with our members, and then Narumi is gonna do her share. Okay. Shaya, quer abrir o microfone e fazer pergunta? Prefere que a gente faça? Shaya tá aqui? Acho que o Shaya não tá mais aqui. Okay, so Rafael Shaya actually asked if you professors would know how to respond to how image generated by AI would be sold by, and how it worked with NFTs and the prices on it, or how that would work.
Is that a question for either professor?
Yes.
Okay.
Is that an
After
answer
you,
for this
Luca.
question?
Oh, ok. Thanks, Ryan. Posso, então, já que os dois vão responder, posso responder em português? Okay.
Claro.
Professor, I told that since we are both answering this question, I will answer in Portuguese, so we have a bilingual answer. Então, nesse caso, na verdade, eu confesso que eu não parei para imaginar muitos problemas relacionados se o que estivesse sendo ali objeto do NFT fosse uma criação ali da inteligência artificial em termos de mudanças. Porque, na verdade, o NFT a gente pode ter sobre imagens protegidas, sobre imagens que não têm proteção pelo direito autoral e sobre essas imagens protegidas por IA. Então, eu acredito que a gente tendo uma visão, e aí solução, eu estou sendo muito otimista em falar, mas a gente tendo ali uma ideia do que fazer com as obras, as criações, produtos gerados pela IA, eu acho que não vai ter tanta diferença para o NFT, mas assim, eu confesso que eu estou nos estudos preliminares ali de FT, então se existe algo técnico que eu possa ter desconsiderado, mas acredito que não teria ali muita diferença do que a gente estava conversando aqui para produtos em geral. Professor Ryan, please. You have the floor.
Oh, okay. Well, I doubt it will be as good as your answer, although I couldn't understand your answer, but I'm prepared to assume it will be a better answer than mine. And, you know, someone clearly sees a business model here. So congratulations if you're planning to go make a lot of money, and don't forget, you know, the professors when you've come into your wealth. I don't necessarily see a particular overlap between an AI-generated invention and an NFT, but I will say this. You know, NFTs are one sort of means of essentially prohibiting copying or establishing an ownership system that is based not as much on law as on, for example, code. So let's say, for example, you had an AI-generated work that had a really substantial commercial value, but because it could not be protected by copyright law, anyone could copy and use it. Well, potentially an NFT could allow you to have essentially a physical way of controlling ownership so that only one person could own it, and that would essentially take it out of the copyright system. You know, so I think in that sense, things like digital ledgers and blockchain and tokens are one means of essentially circumventing our IP system. Of course, one would have to get it to work just right so that people couldn't essentially find a way to copy the thing. But it is interesting, for example, that Christie's, which sold a piece of AI art 2 years ago for about $500,000 in the US, that piece has no copyright protection, right? If it really is an AI generated piece of artwork, except maybe someone has a particularly nice copy in a nice frame, and well, maybe you can do the same thing with an NFT.
It makes sense, I suppose. It's a difficult topic. Alan, tinha levantado a mão?
Yes. Posso perguntar direto?
Pode.
Okay. I'll ask in English so that Ryan can be in. So thank you both for the presentations. I really liked it in a Monday evening here. So we've been talking about AI all day long, me and Luca. We were at a panel earlier before, also on AI. But it's much more of a provocation. I want to hear what Ryan has to say about it, especially. I do think the contemporary copyright system does hold a window for AI protected material, at least in Brazil, when we have neighboring rights and related rights. And that is one example which, when we talk about related rights, there are two major groups. One of them is like for artists and musicians, so when they are acting and playing on it. The second one is for investors, like broadcasters and phonogram producers. And phonogram producers are the only right they have is on the recording. So it's on sound recording. So, when it comes to sound recording, it doesn't matter if it's a human made, if it's a frog made, if it's like a whale song, whatever it is that's recorded can be, it is protected by neighboring rights, which within the whole scope here would be under author rights legislation. And there's nothing that stops AI systems from, once recorded, like sound recording, once they generate a sound recording, that sound recording itself is protected. And it is protected because of investment. The justification is simply investment on that. Sure, there were other ones, but in fact, that was it. So I haven't really seen much. I've been writing on this when we were talking earlier about what I'm doing on AI and copyrights, like seeing, we think the copyright scam, what are the windows that actually show us, in fact, that we are moving away from, I think we are moving like quite a long way from this anthropocentric, the idea of author, human-centered creations. And that has to do with a broader trend, which is shortening what's really species specifics. Like when, by the time AI came about as a name, we're also moving ahead. Don't say like humans, not only humans, but other animals also use technology, meaning tools. They also do language. They also, now there's like, well, less intense now because it seems to be overcome, like, well, even culture, like transmitted knowledge and so on and habits. So this human-centered view on what's Homo sapiens sapiens seems to be being deconstructed like in the last 6 to 7 years. And I don't see why not. It's not going to be on one of the things that's been said. It's very human, the idea that we can create culture and so on. But what they're talking about culture is the culture, high culture that we were seeing when copyright came about, like in the 18th, 19th century. And in fact, technically, we can produce or mimicate something that's similar to an artwork artificially. So the question is for both of you, don't we already have some sort of protection for AI produced music that has been recorded, even by their own system or not? And if we do so, it means that the, well, author rights and neighboring rights are read hosts or has a window for AI protected works, sound recordings, for example. And I want to know from both of you, what do you think? Can we expand that from other sorts of creations? And would that be a model that we could use for such? Warner has had like a few CDs with lots of songs. There are plenty of them going around. So that's the question, comment. Thank you.
A good provocation. Luca, you're up first.
Ok, thank you, Ryan. Bom, eu sou suspeito para comentar especificamente essa provocação, que a gente tinha conversado já sobre isso antes, em outra oportunidade, e realmente faz bastante sentido, eu concordo integralmente com a possibilidade da gente se basear nessa, não é uma brecha, né, mas definitivamente não foi proposital também, mas se basear nesse dispositivo, se basear nessa dinâmica para a gente pensar e aí como lidar, por exemplo, com outros elementos, né? Então, quando a gente fala aqui do fonograma, eu acho o que o Alan levantou, acho que é o exemplo perfeito. Ele está focado ali. Qual é o fundamento? O fundamento é de fusão. Então, esses produtos também, quem desenvolve esses produtos, de certa forma, é um agente difusor de cultura, um agente difusor de obras, né? Difusor de obras ou produtos. E a gente fala também de investimento, o Ascensão diz, né? Então, ele está fundado no emprego de técnicas complexas, de investimento, que é basicamente o que a gente fala quanto ao desenvolvimento de sistemas de IA. Não necessariamente aquele que está trabalhando num projeto que vai desenvolver uma máquina criativa, né, por assim dizer, ele está pensando no aspecto artístico. Muitas vezes eles fazem, não sou eu, são vários autores que eu já vi comentando sobre isso, eles fazem realmente pela questão empresarial, pela questão do lucro, e não há nada de errado com isso. Então, talvez seja um ótimo ali modelo, talvez já na própria legislação já tenha ali um caminho para os fonogramas, e esse caminho ele pode ser um modelo para a gente expandir para outros, para a gente pensar ali numa regulação mais direcionada para a realidade desses produtos, que definitivamente não é a mesma do artigo 7º. Então, super de acordo também. Professor Ryan, please.
I think you should say briefly what you said, so that Ryan could actually follow in English. I know I'm putting you in this spot, but
okay, no, there's no problem. I said that I am a little biased regarding this situation because Alan already talked to me on this matter, and my mind really blown at the time because we studied this matter for the last 5-6 years. And it was only this year that Alan told me that, whoa, if we use the phonogram, the related rights to the music recording, the law doesn't demand that we have an author, a human being behind it. So I think it relates a lot with the foundations with the justification of an eventual protection to these products of AI, because in Brazil, at least, related rights are founded on the investment, on the employment of advanced techniques, on the work made by technicians, and the diffusion of works and arts and culture. So I think it's perfectly relatable to the AI products, because the project manager, the developer, the person who will be distributing the products, the AI products, will be distributing culture. It will be based on his investment. He wants to retrieve his investment. He wants to get remunerated by it, and it comprises the employment of advanced techniques. So I think it's kind of a model, if not in its full way, because it's in our copyright law. But I think it's a good model to proceed with a special regulation on this matter. I think it was the short version.
That was well said. I'm impressed everyone here speaks English and Portuguese, so the English bits are probably just for my benefit. Which reminds me once of a lengthy negotiation I had with a Japanese pharmaceutical company, but we won't talk about that. I think, Alan, the point is well taken. I haven't seen too much on that. I have actually seen a little bit on that that's not kind of out yet, but it's good to hear you're working on the space. I agree in part and disagree in part. And the part I agree with is, yes, if one cannot get traditional protection for AI generated works, although it is jurisdiction dependent, right, then one looks at creative ways to do that. And I think there are a number of creative ways to do it, either kind of trying to connect into, existing rules, for example, by saying something like, by changing inventorship criteria, or saying, well, someone is an inventor because they recognize a machine's output, even if it doesn't require any inventive skill. Or as you say with copyright, relying on neighboring rights, or something like NFTs or blockchains to kind of take us out of copyright law. And it depends on the jurisdiction. Not all jurisdictions have the same regimes for neighboring rights that Brazil does, although I'm not terribly familiar with Brazil's system. I am more familiar with the UK's system. And of course, it is a more limited series of rights than you have in the UK, than you have, with copyright in the UK. For example, sound recordings protect the recording. So you couldn't copy the recording, but you could, take the creative elements of it and copy those. So you would get, kind of a different, more limited, lower level of protection with, some variation in the jurisdictions and how that would be protected. In the absence of some other sort of protection, I think that's the best companies making that sort of thing could do. But essentially, to me, it still sets up a two-tiered system where you get more protection out of human-generated works than you do out of AI-generated works. And if copyright law exists kind of primarily to generate socially valuable music, and we all want to have good music, and AI turns out to be kind of a better way in which we get music, it doesn't seem to me that it makes a lot of sense to have that two-tiered system. If your philosophy on copyright is really that it exists to protect artists and individuals and to encourage human creativity, then maybe that does make sense, because you want to actively discourage AI replacing people because it can kind of cheaply and instantly make good enough music. And I think some of that also is jurisdiction variable. In the United States, the romantic conception of the author is only kind of invoked now by big companies when they're trying to make lots of money by, protecting their artist's music for, 120 years. In continental Europe, it's still very much alive and a motivating factor in copyright law. So that was at least some rambling from me.
Thank you. We're going to keep on this later, Ryan.
Valéria, tem uma pergunta sua aqui no chat. Você gostaria de fazer ou a gente pode ler para você? Valéria? Okay, I'll just read her question then. Okay. So Valeria Bastos asked, Professor Abbott and Professor Shihu, do you agree that at a time in history when everyone around the world is concerned about regulating data, for example, GDPR, and about the impacts of AI inventions, society would not have the right to know that an invention was actually a creation of an AI system? Should the law be modified and harmonized the way around the world? Well, I actually agree that it should be harmonized, but I would like to hear from both of you.
Okay. Thanks, Valeria, for the question. I do agree with you regarding the harmonized way around the world that we must treat this question, because as Ryan said, if we have some jurisdictional conflicts, it will be harder to make business internationally. So countries will not feel comfortable to make business with countries that does not recognize a machine as an inventor or as an author. And regarding the right to know that an invention was actually created by an AI system, sure, I do agree with you as well. I think it must be disclosed, and most of all, during all the decisions, mainly the sensitive one, the human has to be in control. I think this is the main thing. More than we know that it was made by an AI machine, at all times a human supervisor must be accompanying the research, the results, the selection, the filtering, and I think something like that. Thank you, Valeria. Please, Ryan, you have the floor.
Sure. Well, I think these are two different questions. One's kind of on harmonization. One is the right of a public to know an AI generated a piece of work. You know, if there is not a difference in how an AI and a human generated invention is protected, then, you know, the benefit of knowing that an AI made the work, you know, is mainly a matter of human moral rights, because it protects for people acknowledging legitimate human ingenuity and prevents someone from putting their name on 10,000 applications by, you know, AlphaFold. But, you know, as a matter of protection, again, at the end of the day, Google owns all the patents anyway. So as an economic, practical matter, it's probably less important. You know, harmonization has both a good and a challenging side to it. You know, on the one hand, imagine you had a company in Brazil that made AI generated music, and you had kind of a world's best-selling song that you had invested a lot into, and only Brazil protected it, and the UK and everywhere else in the world, they were just free riding on your innovation. You know, that would have some market dysfunction for a variety of reasons. You know, on the other hand, if you were in a jurisdiction that thought, you know, all of these AI generated works, whether patent, copyright, design, or otherwise, are going to be coming out of the US and China and Europe. And, you know, in our developing country, we're really just going to be paying rent to them to use their products. You might feel differently about the harmonization question. So, you know, we live in a globalized world of trade, and harmonization has a lot of benefits, you know, but it is also something jurisdictions have to give some careful thought to.
Okay, that's perfect. Arumi, você me escuta bem?
Agora tô.
Ah, tá. Eu falei que esse é o seu campo de atuação e eu sei que você tem algumas perguntas, se você quiser fazê-las agora.
Obrigada, Sabrina. Thank you, Sabrina. So, first of all, thank you both of you professors for being here with us and sharing so much knowledge. So I would like to bring two topic issues. The first one is when we talk about algorithms and AI, it always looks like that it all comes about the black boxes. So some of the decisions regarding DI systems and intellectual property, they say that we have a problem because we cannot explain the process of creation DI went through. So it's really all about the ability and the possibility that the AI can explain how it process her of development and the creation of a product, because you know the Alpha Star playing StarCraft, it was able to show how it thinks, how it makes decisions. So is that really something that can matter, really influence the decisions if the product, the art or song or patentable products is really able to be protected by copyright? And my other question is about what is the really obvious product? When we're talking about AI products, how we can define what is really obvious? Because you know, AI can create everything, just like Professor Abbott said. At some point, maybe we will have every remedies, medicines that can be created. So how will we deal with it?
Harumi, my PC frozen in the second question. Can you repeat please just the second question?
For sure, sorry. About the non-obvious products generated by AI, how we can establish what is obvious for AI creation?
Okay. Okay, I think both questions are related to patents, to AI inventions, or the first one you aimed to discuss copyright as well.
Mostly about patents.
Okay, in the final part in last year, December, November, and October last year, I was reading some papers regarding the AI created inventions. Read some of Ryan Abbott's paper as well, and the Dabus case were quoted in all the articles on the subject matter. So it was very, very nice to read it. And one thing that's touched me the more was the proposal of doing something like the biotechnology and the microorganism deposit scheme. So there were like 2-3 professors that proposed that we already have, at least at Brazilian legislation, we already have a mechanism to deal with this transparency, to deal with this need for explanation on how the invention works. So as well as the microorganism, you can deposit the algorithm, you can deposit the database that trained that algorithm. It's something like tricky because when you disclosure how the algorithm functions or which database you had to use it, you have to consider also the trade secrets that are involved there. But some professors, and I would love to hear Professor Ryan Abbott on this matter, suggested that we adopt something like the microorganism patents, when you have to deposit the algorithm and deposit the database that trained the algorithm at the time of the deposit, because it's not only about technical opacity, but it's all about mutation as well. They were worried about the mutation of the algorithm with the training, with the changing of the database. So I'm sorry not answering to your question and adding another question to Professor Ryan, because I would love to hear about it from him. And I think the non-obvious criteria, it's kind of difficult to know, because when something that is obvious for a human being, it won't be obvious, probably won't be obvious to an AI system. So I think it's urgent to differentiate the patents that are developed with the help of an AI, the AI developed patents, the inventions, sorry, and the AI related inventions. So I think the IP trends from WIPO 2019 have some data on these 3 kinds of patents, and I saw in some articles as well the need for distinguish these 3 kinds, so we can work on the non-obviousness. Because when you talk about an AI invented, an AI created invention, I think the non-obviousness criteria is much different than a human invented one. But when you talk about invention that was created with help of an AI, so the FOSITA, the PHOSITA, no caso seria aquele nosso técnico do assunto, né? Would be considered a technician with a help of an assistant and all the tools that are available at the time of the invention. I don't know if I answered or just confused a little more this tricky question, but it's very nice to talk about. Ryan, please illuminate us regarding these topics.
No illumination, but some final rambling I'm happy to engage in. With what the computer process question is interesting. I mean, for an AI generated invention, I do not think it is terribly relevant. So for example, if you take the patent of the Siemens car suspension, it really kind of doesn't matter how it is that the AI got there. The question is, well, would an average person have found this obvious or not? So really, how the AI generated that invention is kind of irrelevant. That is, not the case in two potential instances. One is if there is litigation involving the patent, there may be some questions about how the AI came up with it. And, traditionally one deposes inventors and asks them questions, and you're going to have a hard time doing that with an AI. It will just look different. You will have forensic experts looking at what the AI was trained on and what it did and whether it was using someone else's design and so forth. And that's going to be an interesting aspect of litigation. I think kind of the relevance of that point is more back to computer implemented inventions. If you have a process for something using an AI, it is not that useful if really the magic ingredient is a data set that an AI is being trained on, and just kind of saying hypothetically, first you have an AI, then you train it on our data set, and then it can do this cool thing, is not that useful as a patent. One solution people have suggested for that is depositing data sets, right? Of course, many companies are reluctant to turn over their secret sauce, but maybe that means they shouldn't be getting patents where they're withholding the secret sauce. And, there are difficulties with having repositories for this and data breaches and personal information and so forth. So, I'm still thinking through some of that. And the other point was, I forgot what the other point was, right? What are we going to do when machines are able to invent everything? Well, that is, I think, really kind of the end of the need of the patent regime. But I should say it is at a minimum likely decades away. And at a maximum, some people do think that will never happen, or it will take centuries until something is really immediately obvious to a machine. But really, if you did have machines that were that sophisticated, you wouldn't need a patent system anymore, because we would already have them. They would costlessly generate innovation, and you wouldn't want monopoly rights without some kind of offset to that.
Okay, thank you so much, professors. And I know we're reaching our time, so I will just ask a little patience, out of curiosity alone. Professor Abbott, at the end of the lecture, you've said you take into court the case of a patent in AI. Do you have a guess of, are pessimistic or optimistic about how the court's going to rule on the matter?
In Brazil or internationally?
Internationally, or maybe, well, in Brazil, I'm clueless, I'm going to tell you, but so far, apparently, we are more human-centered, and I think maybe Professor Shu can help us with that. But internationally, I'll be curious to know.
Internationally, it is my prediction that some jurisdictions, but not others, end up protecting this, and they may do it on some bases or another. So, for example, Israel does not require an inventor to be disclosed in a patent application. So one could protect this right now in Israel simply by not disclosing an inventor. There are many other jurisdictions that will simply issue a patent based on a published PCT application, right? So you have seen we already have one of those. So there's another hint. A couple of members of the European Patent Convention, Cyprus and Monaco, have reported they do not require inventors to be natural persons. So I think already there are some jurisdictions that are likely to allow this. You know, the US, the UK, and Europe, I think, are thinking very deeply about it. So is China, but I think really in the past decade, this has gone from something that has been a novelty to something that is of mainstream interest to certain sorts of industries. And I think there is going to be, if not judicial success with the case, policymaking success with the case in some of these major jurisdictions in the next few years. But who knows these things?
Yeah, well, just predictions. Professor Shehu, do you have an idea in Brazil how we're going to do with this? I mean, you've explained a lot in your lecture as well, but do you have a guess for the future?
Well, regarding the law as it is today, I think it is difficult to pass before the BPTO, but what I know is that the BPTO and some related bodies are working hard in webinars and studies commissions and hiring professionals to provide some consultancy regarding the subject matter. So I think we have something very soon on this matter, but I think I don't want to risk to point one or another answer because it's being recorded, but I'm sure that they are discussing it very deeply, and I'm eagerly to read what will be decided from the Dabus decision. And I don't want to be rejected, but if it goes to court, it will be even nicer because we will have the judge discussing it. But let's hope that we will not need to go to court.
Yes, absolutely. So we are really at the end of our presentation today. I'm so happy to have you both here, and I want to thank you both so much. And I don't know if you have any final requests, questions, or any final words from professors. I'll be more than glad to hear it. That's all.
Well, I was going to let Luca go first, as was our convention, but just
yes, of course, it's a pattern.
To very briefly say it was a real pleasure to be here with everyone. Thank you for the wonderful questions, and I hope we get to see each other soon in Brazil.
Oh yes, to take a caipirinha. I agree. Thank you.
Thank you all. I'm very, very happy to be here to share these moments with you. Thank you, Professor, all the organizing committee, and all those who were present here to promote these debates. And as Ryan said, I'm looking forward to the caipirinha time and to another event and events in caipirinha after as well.
Thank you. Então tá combinado, passando a pandemia, a gente vai ter um evento com caipirinha para discutir propriedade intelectual e outras coisas de robô, como diz a minha orientadora. Gente, muito obrigada pela presença de todo mundo. Vocês estão livres para curtir o resto da segunda-feira. Thank you all. That's the end of it. And I could not be more happy with the great participation of all of you, the great members and professors. Thank you again. Okay.